it must dismiss the appeal, and the better practice is not to proceed to opine about the merits of the issues. Briefly, I understand that the court is very familiar with the case facts, but just a brief recap of certain case facts. It's good to remind the court that Mr. Ferguson was convicted to one count of aggravated kidnapping, one count of rape, and one count of aggravated burglary. He was sentenced in October of 1998, but he has been incarcerated after being taken into custody since September of 1995. As we earlier indicated, the Court of Appeals has previously affirmed a prior decision in this matter. In March of 2004, Mr. Holland filed Mr. Ferguson's first 1507 regarding ineffective assistance of trial counsel. That motion listed 14 claims. In January of 2007, the district court set Mr. Ferguson's disposition motion for a February 28th, 2007 hearing with notice to counsel for all parties. At the hearing, state counsel appeared, but Mr. Holland did not appear on behalf of Ferguson. Therefore, Mr. Ferguson's remaining motions claims were summarily dismissed. On March the 2nd, 2007, the court decision and final order was filed. Copies of that order were sent to Mr. Ferguson's attorney, Mr. Holland, and nothing thereafter was done by Mr. Holland on behalf of Mr. Ferguson in that particular case. As indicated in January of 2017, undersigned counsel filed a motion to reconsider that prior decision, and the final order entered on March the 2nd, 2007. A subsequent evidentiary hearing was held on the motion. In September of 2019, the district court submitted its decision. Mr. Ferguson appealed, and we've already talked about the first decision of the Court of Appeals, the panel decision, basically dismissing that motion to reconsider without making any determination on the merits of Mr. Ferguson's original 1507 against his trial counsel. On May the 26th, 2022, Mr. Ferguson timely filed his second 1507 motion alleging ineffective assistance of counsel of Mr. Holland. On August the 12th, 2024, the district court issued its ruling, and this appeal has timely followed. So essentially, Mr. Ferguson's arguments in favor of relief are as follows. In 2004, Mr. Ferguson and his sister retained Mr. Holland to file a 1507 motion against his trial counsel. Having received no state case status report, in the summer of 2007, Mr. Ferguson's sister contacted the Holland Law Office and had discovered that Mr. Holland had been ill and passed away in June of 2007. Mr. Holland's son advised no firm member had appeared at the district court February 2007 motion hearing to argue the merits of Mr. Ferguson's motions claims. In January of 2008, my client's sister wrote the Holland Law Firm to inquire about case status. Mr. Holland's son responded in a letter dated January the 28th of 2008, concluding, "I hate to be the bearer of bad news, but it would appear from all the facts which we have before at this time that we have reached a proverbial dead end." Thereafter, Mr. Ferguson signed and received a consent from the Holland Law Firm for the case record to be sent to his sister. Mr. Ferguson's sister reviewed the records sent from the Holland Law Firm in 2009, and received the records in 2009, and those records remained in her possession until late 2015 or early 16, when Mr. Ferguson began to review his records. Mr. Ferguson had been under the impression that his motion had been dismissed on the merits, when the reason, however, for the dismissal is that his counsel simply did not appear for the hearing.
So therefore, counsel, just to focus on this timeliness issue. So, I mean, what is the explanation for the delay? If we're looking at a manifest injustice standard here, what is the explanation for that delay between the time when the sister was notified in 2008 that this was a dead end and the filing, I mean, at minimum, the filing of the motion to reconsider in 2017?
That's correct, Your Honor. The short answer, Your Honor, is that Mr. Ferguson had the belief and impression that his case had been dismissed on the merits, and so that there was nothing further that could be done. It was only when it was later discovered by research from a fellow prisoner that he determined, no, the case had not been dismissed on the merits, but had been simply dismissed because Mr. Holland had never showed up for the hearing.
But the sister knew in 2008, correct?
Well, the sister had received the records. That's correct, and had a contact with the Holland law office. But of course, she's not an attorney, and she was not advised explicitly that the case had been dismissed due to Holland's failure to attend the hearing, as opposed to a determination that it had been dismissed simply on the merits.
And so what was the first action he took? Was that in 2000, did you say 15 or 16 when he contacted your firm?
That's correct. When he contacted me, then the next subsequent action was the motion that I had filed on his behalf to basically set aside and have a determination as to whether or not the motion should have been dismissed in the first place. In other words, a motion for reconsideration that I had filed.
And that was in 2017?
I believe so. Yes, I think that's the date here. Let me take a look at my file. Yes, I had filed that motion in 2017. That's correct.
You may continue if you'd like.
Oh, thank you. All right. So getting back to the argument that my client wishes to make with regard to the issues, the paramount issue most likely is obviously whether this motion is time barred or res judicata.
Sir, you have 1 minute left.
Very well. The issue is, and this is all set out in our brief, that it is not only the motion is not only timely filed, but also should be permitted under manifest. It's an injustice to permit to deny Mr. Ferguson the opportunity to have the motion on the merits of his hearing heard before the court. And those issues have been set out in my brief, Your Honors, and on page, the timely filed is on page 16, citing the Roll versus State case, and the manifest injustice is on page 17. And we would also argue that, of course, the trial court, in not resetting the hearing that was dismissed in February of 2007, essentially committed a due process violation, and that is talked about on page 14 of my brief.
Thank you. Perfect timing. Your time has expired and you'll have 3 minutes left for rebuttal.
Thank you.
All right. And counsel for appellee, you may begin.
Thank you, Your Honor. The state's position is that the timeliness issue is the primary issue in this case. Obviously, the petitioner relies heavily on Rowell for his argument that this case was timely, that the time for filing a subsequent 1507 alleging ineffective assistance of counsel in an original one does not begin running until the mandate is issued on the first appeal. However, reading the Rowell case, my reading of that is that they were applying the manifest injustice standard in that case and determined, I think rightly, that it would be manifest injustice to bar a claim of ineffective assistance in a 1507 before it had arisen. And since the alleged ineffective assistance in that case did not occur within the 1 year time period from the original appeal and the direct appeal, he could not possibly have filed it within that 1 year time period. So that would constitute manifest injustice, justifying an extension of the time limit. In this case, however, the alleged ineffectiveness occurred in 2007. The petitioner testified at the preliminary hearing that he received a letter informing him of what had happened in 2007, but he didn't read it. So he knew, or should have known, in 2007, he's attributable with the knowledge in 2007 of what had happened in the hearing, and he didn't do anything until 2017. I also believe, and I apologize, I don't have the exact dates in my right in front of me, but even once he personally received the records in, I believe, 2016, even if you count from that date, his motion was still not filed within a year. It was filed in 2017, but beyond a year from the time that the petitioner personally received all of the documents in the case and would have had access to the information necessary to file this, to file his original motion.
Mr. Audit,
Yes.
that letter that Mr. Ferguson received in 2007, did that make clear to him did that make clear to him that Mr. Holland had not appeared for the hearing?
I believe that it did, and I apologize. I don't have in front of me the exact record citation. I also handled the original appeal, so I recall from doing his original the one in the previous one, that my recollection is yes, that it did, but I don't have a record cite to back that up off the top of my head. I apologize.
Thank you.
But and his sister, at the petitioner's request, the records were sent to his sister in, I believe, 2008. So I would argue that since that was at his request, that is also attributable to him. She was acting for him in that case. He had access to these documents and simply did not review them, did not look at them because he thought he knew what had happened. But that's on him. That's not anyone else's fault. He's the one that sat on his hands for 10 years before he did anything. And so I think applying the rationale in Rowell, as I said, I agree with the reasoning that it would be manifest injustice to bar the claim before it arose. But because of that, I believe Rowell stands for the proposition that the time period for a subsequent 1507 begins when the previous 1507 becomes final, which would have happened after the time period for appeal of the district court's decision expired. So that would have happened in, I believe,
Rowell specifically cued to the ineffectiveness of 1507 counsel.
Yes, and since in this case he's alleging that the petitioner is alleging that his original 1507 counsel was ineffective by not appearing at that 2007 hearing, the time period for bringing that, I believe, would begin running once that first 1507 proceeding became final, which happened in 2007 after the time period for appeal expired with no action on his part. I believe if the court adopted petitioner's reasoning or reading of Rowell, then it would effectively eliminate a statute of limitations for subsequent 1507s because a petitioner could always file any kind of motion to set aside the judgment or do something and lose that motion and then say, well, now this is the time for my clock to start, because his motion to reconsider was well, the district court decided it both on the merits and based on timeliness. It was appealed, and the other panel upheld that decision based upon the timeliness. But he filed an untimely motion to reconsider and is now trying to use that untimely motion to reset the clock of the 1 year to file this subsequent motion. And that I just don't think there's any support for that. Additionally, I believe that even if this motion is timely, And as I state in my brief, in order to obtain relief for ineffective assistance of counsel, the petitioner has to establish that both the representation was ineffective and that he suffered prejudice as a result of that. And I do not believe that he can establish there was any prejudice in this case. He did ultimately, after the motion for reconsideration was filed, there was a preliminary hearing in this case in which the district court heard evidence on his claims of ineffectiveness in his original trial. So the things that Mr. Holland was supposed to be arguing in the hearing that he didn't appear for. And the district court ultimately did hear evidence on those claims and ruled against him on the merits. So I do not believe that even had I don't believe there's any way that the petitioner can establish that even had Mr. Holland appeared and there'd been a hearing on the merits in his original 1507, I don't believe he can establish that the result would have been any different, that he would have prevailed. And he has to establish that he would have prevailed in order to establish prejudice, justifying relief in this case. So those, I think, are the two primary. Obviously, I also argued in my brief, and I would ask the court to consider the res judicata issue, that the merits of his 1507 claims that he's bringing now have been established on the merits, or have been ruled on the merits against his interest, and so he cannot relitigate that now. And I would simply
Mr.
ask.
Buddy, I'm sorry to interrupt, but when we're talking about claim preclusion here, I know that the district court discussed Holland's ineffectiveness, but didn't that become judicial dictum when the Court of Appeals expressly did not address the merits of that argument on appeal?
I looked into that and I couldn't find any case law that explicitly addresses that question. I did find, and I cite in my brief, several cases where courts treat things as res judicata, even though they were not addressed on appeal. So I believe the fact that it was adjudicated on the merits acts as a bar, even though on the appeal, the appellate court didn't reach that question. But I was not able to find anything that explicitly addressed that, just several cases that seem to assume it without ever explicitly stating it. And I do think I would argue that is the reasonable position, because other appellate courts frequently do not address every single issue that occurred in the district that was addressed in the district court. And if the failure or the appellate court not addressing an issue meant that res judicata didn't apply, then litigants could bring up other claims over and over again that hadn't been appealed, even though they had already been determined at the district court level. And so I do think that is the more reasonable position, but in candor, I have not been able to find any case law that explicitly says that is the rule.
Thank you.
And if I believe that's everything I have, unless there's any other questions from the court, I would cede the rest of my time.
Are there any other questions? Seeing none. All right. And Mr. Alexander, we will turn to you for your rebuttal. And I've got the timer at 3 minutes. You may begin.
Thank you, Your Honor. It's explicit in that decision that I had previously quoted, the first decision, case number 122209, last page, paragraph 9. Once the Court of Appeals finds it lacks jurisdiction over a case, it must dismiss the appeal, and the better practice is not to proceed to opine about the merits of the issues. There's a case cited. As a result, we will not address the merits of Ferguson's ineffective assistance of counsel claims. So I think it's pretty obviously, Your Honors, that the merits of Ferguson's ineffective assistance of counsel claims have never been resolved. Yes, the district court ruled against him, but to take the position of the state in this matter, that would leave Mr. Ferguson or any other litigant no alternative or no option if they wanted to appeal that decision. And that surely cannot be the law and surely should not be permitted. So the merits of the original claim have still not been resolved. all this period of time, and that is exactly what Mr. Ferguson is asking for, an opportunity to have the merits of his claims ruled upon by an appellate court. The other thing is that I believe, and I need to check that out, but I believe that letter from the Holland law firm to my client's sister is in the record. And certainly if the court has the time to do that, I would certainly ask that that letter be reviewed. It's my understanding, well, rather it's my client's understanding that it was never explicitly explained to either my client or his sister that the case had been dismissed on the merits. My client, for all these many years, thought it had been until his discovery. Once he got the case file and had an opportunity to look at it in 15 and 16, that no, there was never a dismissal of the case on the merits. It was simply because Mr. Holland failed to show up at the disposition hearing in 2007. Surely we can agree that it is prima facie ineffective assistance of counsel if a counsel does not show up at a hearing for a 1507 litigant, and that's exactly what we have here. So giving all that information and given that situation, we would simply request that the court grant relief to my client in his appeal that is pending.
Thank you. Are there any questions? All right. Seeing none, that will close today's argument. Thank you very much for being with us today, and we will consider the case and issue a written opinion as soon as possible. Thank you both. Have a good day.
Thank you.
Thank you.